Texas versus Johnson, 491 U.S. 397. In 1984, Gregory Lee Johnson, as seen on the right, violated the Texas flag desecration law, which prevented the flag from being publicly defaced, burned, or trampled upon. Johnson was tried for burning the flag of the United States of America in front of the Dallas City Hall. The purpose of the burning was to protest the Reagan administration's policy. For this, he was sentenced to a year in prison and received a $2,000 fine. He first appealed to the Fifth Court of Appeals of Texas and lost the appeal. He then appealed to the Texas Court of Criminal Appeals, which overturned the conviction and asked the Supreme Court to review their decision. 5 years later, in 1989, the Supreme Court held the hearing. The court voted 5-4 to affirm the verdict of the Texas Court of Criminal Appeals. That meant that Johnson was found not guilty of any crimes. During this case, the constitutional provision at issue was the First Amendment, specifically freedom of speech. The two main legal questions were, is the desecration of the United States flag for protest protected by the First Amendment? And do the states have the right to ban the desecration of the United States flag? The opinion of the court was written by Justice Brennan and joined by Justice Marshall, Blackmun, Scalia, and Kennedy. The important ideas of that opinion are that Johnson's actions were protected by the First Amendment because his actions were symbolic in trying to send a message. So although his actions may have offended some people, that does not justify prohibiting the people's freedom of speech. The court also decided that states could not limit what a symbol could be used for, like the flag being a symbol of a nation, meaning that if someone wanted to use the U.S. flag as a symbol for something else, like Johnson did, state officials could not limit what that symbol was. Justice Kennedy also provided a concurring opinion. He stated that he does not want to qualify Brennan's statement in any way, but simply wants to mention that the hard fact is that sometimes we must make decisions we do not like. We make them because they are right in the sense that the law and the Constitution, as we see them, compel the results. So what he is saying is the decision that the justices made was not easy and they did not fully like the outcome, but it was the right and just outcome. There were two dissenting opinions written, one by Justice Rehnquist, joined by Justice White and O'Connor, and the other by Justice Stevens. Rehnquist's dissenting opinion was that the flag had a unique status and that the American flag then, throughout more than 200 years of our history, has come to be the visible symbol embodying our nation. It does not represent the views of any particular political party, and it does not represent any particular political philosophy. The flag is not simply another idea or point of view competing for recognition in a marketplace of ideas. And because of this status, this justifies a governmental prohibition against flag burning in the way respondents Johnson did here. So, Rehnquist believes that the U.S. flag is not a basic symbol that can represent whatever the people think it does. It represents the U.S. nation as a whole, and that it should not be allowed to be desecrated. Justice Stevens' dissenting opinion was very similar to Rehnquist's. The main difference was that Stevens specified that the case has nothing to do with disagreeable ideas. It involves disagreeable conduct that, in his opinion, diminishes the value of an important national asset. This is saying that Johnson should be punished not for the idea, but the way he demonstrated that idea. The main influence this case had was that it ruled that the burning of a flag in public is protected by the First Amendment. This decision can also possibly affect future cases of radical protests. The notes offered by the dissenters can influence cases that deal with national symbols or landmarks like protection of the bald eagle.